think we're live.
Okay, well, welcome everyone. This is the Banking, Consumer Protection and Commercial Law Subcommittee. So the day is February the 14th. Happy Valentine's Day to everyone. Okay, well, welcome everyone. This is the Banking, Consumer Protection and Commercial Law Subcommittee. Sorry about that. So today is February the 14th. Happy Valentine's Day to everyone. Okay. All right. So we are going to talk about, first I want to welcome Delegate Harrison to the committee. Thank you for joining us. So we're going to talk about HB 251. This is a Consumer Protection, Maryland Consumer Reporting Act, Registration of Consumer Reporting Agencies and Regulation. This is from Delegate Polakovich Carp. I believe she's on the line as well. And so we heard this in committee, and we had several favorable amendments and a few unfavorables. So I do want to bring you up to speed, though. I think we got an information letter today. So I wanted to let our counsel Tiffany Clark talk a little bit about that, what it was said, and then we can go into the debate about this bill. Is that okay?
Okay, that works for me. Do you want me to go over the bill first and then talk about the letter?
Let's do a rehash of the bill just so everybody remembers the bill, and then talk about the amendment and then the letter of information. Okay.
Okay, sounds good. Okay, so this is House Bill 251, Delegate Polakovich Carr, Consumer Protection, Maryland Consumer Reporting Act, Registration of Consumer Reporting Agencies and Regulations. This bill authorizes the Commissioner of Financial Regulation within the Maryland Department of Labor to deny, refuse to renew, suspend, or revoke a consumer reporting agency's registration if the consumer reporting agency has provided incorrect information, committed fraud, failed to comply with the bill in any way, or violated state or federal law. The bill also requires the Commissioner to adopt regulations to ensure the maximum possible accuracy and matching data in a consumer's file with personally identifiable information from any public record being reported by the consumer reporting agency. And it goes into details about what that consists of. It also requires the Commissioner to develop a system for the exclusion of duplicate, outdated, sealed, and expunged public records, and tracking and addressing the causes of consumer complaints regarding inaccuracies in consumer reports. So there is one amendment from the sponsor, and that prohibits a financial institution that complies with the act from being held liable from the disclosure of information taken in good faith to comply with the requirements of this act in relation to the Social Security Act. As Delegate Queen said, there was, we got a letter of information from the Department of Labor, so Office of Financial Regulation. Did everyone get that? I sent it maybe about 2 hours ago. Okay, and basically what it says, it discusses what the office has done in relation to regulations for this. I believe in October 2020, they just adopted a new set of regulations. And basically it says that what they're doing is already covered, or the law, what they're doing is already covered by it. Also, they bring up an issue about the preemption, and they're saying that while it may not be expressly preempted, it might be implicitly preempted. And I believe they're asking for a little bit more time just to figure things out.
Okay, thank you so much. Any questions on any of that before we start to kind of discuss the bill? Anyone have any questions at all? Let me make sure I'm familiar. Yeah. Delegate Harrison.
Thank you. So if the department says that they're already doing this, then wouldn't this then just be a matter of codifying it?
No, I think it's a little bit more complicated than that, specifically about, and The department was extended an invitation. However, their legislative liaison was not feeling well today, so they couldn't come to explain this. But I think the issue that they're trying to get at is that that preemption thing. If you look on their little letter of information, I'm going to read directly from it because, like I said, I don't want to put words in their mouth or anything like that. It says, the maximum possible accuracy standard is also found directly in applicable federal law, which does not limit the criteria a CRA may use to achieve the standard. The conflict between state and federal law on achieving the maximum possible accuracy standard does not appear to present a direct conflict creating preemption issues. Notwithstanding, the provision does appear to create an indirect conflict that could create uncertainty for any regulation that OCFR issues, as well as for CRAs. Additionally, the specification of state-specific criteria, which are narrower in scope than those permitted under federal law, could limit a CRA's ability to produce accurate information utilizing other tools and factors.
Okay, I'm looking forward to just hearing the discussion on this. Thank you.
All righty, Delegate Jackson.
So it sounds like some of the obligations that is in the bill, the Department of Labor is saying that those are duplicate actions and they're already being taken.
Correct. They're saying that, and then they're also saying that I think because of the specificity that this bill has, it might create some issues and confusion in addition with federal law.
Okay.
Or how they're interpreting federal law.
All right, thank you.
Is that all your questions? Okay. Delegate Watson.
Yes, I was just wondering if we have, or if we could have a summary of what exactly the bill, what problem the bill is trying to solve.
Me or the delegate? I don't.
Well, probably, I guess it's best asked from Delegate Carr, if that's okay with you, Madam Chair.
Sure, it's fine with me. Delegate Carr.
Thank you, Madam Chair. Thank you, Delegate Watson, for the question. So, I mean, the bill is trying to get at inaccuracies on consumer reports, that there are consumers who have very material errors on their consumer reports, and many folks aren't aware that they have recourse potentially to get those corrected. But even for people who pursue that, and I think this came out at the hearing, and maybe even from folks who are in this room who have pursued that recourse, they don't see corrections on their reports. So really, we're just trying to get the industry to follow the standards that are already set in state and federal law. I'll say respectfully in terms of the regulations, that although Maryland did recently promulgate regulations that I think maybe about 1.5 years ago that those were put out, they don't address all of the types of data that would be subject to this bill, nor to all of the parts of how a consumer report actually is compiled and all of the steps that are involved in data matching. They are only looking at a small subset of types of data and part of that process.
Did that answer your question, Delegate Watson? Or
Yes, I think so. Thank you.
yeah. All right. So hands sort of came up. I'm gonna go in this order: Fennell, Adams, Motts, then Jackson again. Delegate Fennell.
Thank you, Madam Chairwoman. My question is, I mean, again, you know, since it's already a duplicate delegate, I mean, you know, is it really necessary to make this a policy since it's a duplicate? You know, Delegate Carr.
Sure. So, I mean, I would say actually, I don't view the bill as duplicative of what's in the regulation, that we are breaking different ground than what those regulations addressed. You know, on paper, our state does have laws about consumer reports and regulating those agencies. Mm-hmm. I think we have seen failures, though, of that existing system. And so the other part of the bill is trying to put more teeth into it to ensure that if there are companies that are being bad actors, that the Commissioner of Financial Regulation has enough options and sufficient recourse to actually bring those companies into compliance with state law.
Is there a fee attached to this?
Current law already does set monetary fines for companies that are not in compliance.
Do you know?
So
what
this
that-
law, this bill just wouldn't change those fees, but those are there in statute already.
Okay. And just the last question, Delegate Carr, do you know the fee? Are we familiar what the fee is now?
Yes, can I?
Yes,
If I can
if-
jump in, it's a civil
Okay.
penalty of $1,000 for a first violation and
Okay.
$2,500 for each subsequent violation.
Okay, thank you. Thank you, Delegate Carr. Appreciate you.
Okay, Delegate Adams.
Thank you, Chair and Council. I've got a couple questions. I found this bill difficult when we were having the hearing, but nevertheless, when we talk about personally identifiable information, this was a bill we heard last year, right? Yeah, and so give me some examples, Council, of what you believe would be personally identifiable information, because I think that shows up in this bill, and those that oppose the bill have some real concerns about trying to collect the information. So just kind of walk me through what that is.
Okay, I think personally identifiable information could possibly be like a race maybe, or age. Well, you have age with date of birth, but things that can personally identify you. So like race, height, weight, things of that nature.
Gender.
Gender, yes.
And so the problem with the bill is it seeks perfection in relationship to these records. So the obligation is that the full name of the person is supposed to match the full social security number, and the full birth date plus another personally identifiable piece of information.
Correct.
And the testimony that was given during the hearing was that there was a subset of those citizens who were affected because of the credit report being inaccurate. But then of those people that had an inaccuracy in their credit report, how many of those actually had a negative determination on their credit? And it's a relatively small number, if I understood the testimony correct, not to overthink things, but it's asking a lot of people to ask for those sort of personally identifiable pieces of information, given the fact that these credit reports are highly reliable, and it puts some obligations on private sector to do things I don't think they would otherwise want to do. And just, am I correct in trying to reiterate what was happening during the hearing? That's where I was trying to go with this.
I believe that there was testimony to that. Yes, I believe there was testimony that supports that.
All right, thank you.
Delegate Jackson.
Yes.
I'm sorry,
this-
sorry. Delegate Motts,
sorry.
sorry.
Thanks, Chairman. I definitely appreciate. I believe I understand the issue, and I guess my question is for Delegate Pavlovich Carr. Am I correct in that this bill is focused at the credit reporting agencies, right? That's
Yes.
right. And so I'm interested. I think we deserve, the Department of Labor didn't testify, and they should have. I didn't have a chance to read this letter yet, and I will definitely take a look at it. I think it would be great to have an opportunity at least to talk to the person from the Department of Labor, a representative, particularly somebody in the office that's sending us this letter, so we can ask them some questions about the rights of people who are affected by this. And I didn't know, did you look at just empowering the rights of consumers? So when a consumer gets that report, they've got a quick way to resolve the discrepancy or conflict that they have from the report.
Thank you for that question. If it's okay, I'm actually going to defer to the expert that we have here, Ms. Nelson. I believe that's an issue that may be preempted very explicitly under federal law in terms of having a more timely response from consumer agencies, but she would know better than I in terms of the details of the federal law there.
Thank you, Delegate. Yeah, so preemption could be an issue in that space. And I know that Delegate Pavlovich Carr carefully crafted this bill to avoid those concerns. And I'm happy to answer any questions about preemption. I know that Tiffany mentioned some of them in that letter, and I can speak more to that if it would be helpful.
So I guess my question then would be why, if regulating the credit rating agencies is the issue, why not empower the consumers to have the right to, they raise a question, they get a credit report, they call a credit agency, a credit reporting agency, or have an official communication with them, get a 1 week, 7 days or less response to try to rectify. If they can prove, like if they've got the wrong name and you can give them your if you have the real ID driver's license, I mean, that's a pretty high bar and most people have met that. Would there be a preemptive rule that would prevent the state saying that they shall respect, certain forms of documentation and things like that?
Yeah, so my understanding is that under federal law, the list of the preemptions, I'll say under federal law, is a little bit convoluted, but that is one area where it is clear that states cannot require a shorter time frame for the consumer reporting agency to respond. And I believe it's 30 days currently, and we do not have leeway to shorten that or to compel them to respond in a more timely manner under federal law, unfortunately.
Well, Madam Chairman, I would very much like the opportunity, if we move on the bill, at least to have an opportunity to talk to the Department of Labor or whoever was not available today, to get some answers to some of the questions. But thank you very much. That's all I have for now. Thank you.
Mm-hmm. Delegate Jackson.
Thanks, Madam Chair. And this is for the bill sponsor. The last sentence at the bottom of this letter, and I'll read it. It says, additionally, the specification of state-specific criteria, which are narrower in scope than those permitted under federal law, could limit the CRA's ability to produce accurate information utilizing other tools and factors. Can the sponsor speak to that? What they're saying here, or?
Yeah, and I guess it's a good question to raise. I think it partly depends on which side of the issue that you're looking at. I would say that we shouldn't be including information unless we know it's accurate on a report. I think the flip side of that would be that we potentially are excluding information from a report when we are not as confident that it is actually accurate information about that consumer. So basically what that sentence, I believe, is referring to is the fact that part of this bill would require matching based on specific criteria, like the person's full name, their date of birth, a full social security number. And I'll mention the other personal identifiable information that's included in the bill could be things like a driver's license number, your former residential address, the name of your employer. There's a variety of other factors that we could use to match that information. But really, the heart of the bill is getting at, right now there are inaccurate matches happening. And the question is, do we feel comfortable with including inaccurate matches some of the time, like is happening now, or to move to a system where we're saying that the threshold for accuracy is higher, but it is possible that some questionable data is going to get left out. I don't know if that answers your question.
But that's what we're trying to, is that what we're trying to avoid in the first place from happening? Data?
Having inaccurate information on the report, yes.
So they're saying that this bill will help, they wouldn't be able to, it would limit them in doing that. Is that your understanding of this letter? Of that statement?
So I actually took it as that they agreed that this would help with the accuracy issue, that their concern is that there may be information that is left off that is of questionable accuracy.
All right. Thanks, Madam Chair.
Mm-hmm. I think we have Delegate Rogers, and then after that, I think we'll make some decision.
Thank you, Madam Chair. And I know that Delegate Fennell's raising her hand that she wants to get another bite at the apple as well. But my question to the bill sponsor and even counsel, if she knows, is that, number one, do we know how many inaccuracies are occurring every year? Number two, if we give access or we provide access to this additional PII in whatever form it is, whether you just mentioned that there are several, whether it's a driver's license, whether it's a social security number, whether it's, some other piece of PII, do we know exactly how efficient that would be, or I guess the corollary to that would be how many actual inaccuracies what the rate will be reduced by providing this information? And I guess I'm in the delegate bounce boat. I do need to read that letter that was sent that we got today, because I obviously have seen the bill and looked at it, but I haven't read that letter from the Department of Labor, and I certainly would want to see what that says.
Thank you for those questions. I think that issue of accuracy really is at the heart of this. The most comprehensive study was done by the Federal Trade Commission, actually directed by Congress, maybe starting about 15 years ago. And this was like almost a decade-long study trying to look at this exact issue of how frequent are errors and how harmful are those errors in terms of consumers' potential credit score when they're making an application. And they found that about 1 in 4 Americans have an error on their report. So errors are fairly frequent. As did come out at the hearing. I mean, to be fair, they're not always material errors or errors where it's going to actually hurt someone. However, there are enough cases of where you are seeing people who have material errors that get them a lower credit score, or they get rejected from renting an apartment, or when they've applied for a job because of inaccurate information that shows up on their report. So, I mean, the premise behind the bill is to try to address those issues and to try to head those off. And I think I've forgotten your second question, if you can remind me.
It was really, the question really is, if we provide these additional pieces of PII, what will be the reduction in error rate? I mean, how significantly would it impact folks if we gave them additional PII, which I'll just not read into it anymore.
Yeah, and maybe if Ms. Nelson has any more particular information to answer that question.
I will say, I don't think I can't give you an exact answer about how much it would improve matters. There hasn't been, a study to that effect. But I will say that in an advisory opinion from the Federal Consumer Financial Protection Bureau a couple months ago, they highlighted that consumer complaints to the Bureau about incorrect information on your report have represented for at least the last 5 years the largest percentage of complaints that the Bureau gets about consumer reporting, and that a lot of those errors can be attributed to things that arise during the matching process. So they are also recognizing that this is a huge and ongoing problem. And just in terms of one thing you mentioned, Delegate, about getting the information, I'll say that a lot of, for example, a tenant screening company already asks a consumer filling out an application for most of this kind of information. And so it's a matter of matching that to what is in existence on a public record, for example. So it's not even necessarily that they're collecting more information, it's just that they're using what is in existence.
So I'll finish here. If we don't know what we don't know, might it be more appropriate to maybe do a summer study to see what that actually looks like before we legislate something that we're close to already doing?
Who was that directed to, Delegate Rogers?
Delegate Polakovich-Carr.
Okay.
I think if that's the will of the subcommittee and the committee, I would support that. I think it's a fair question to ask. If people are not comfortable with moving forward now, that could be a good outcome.
Okay. I'm sorry, Delegate Fennell, and then I think we'll wrap up. Delegate Fennell, I missed you.
Actually, Mike asked my question in reference to the accuracy. So I don't have a question. Thank you, Madam. Thank you. Thank you, Delegate Carr.
All right. So anyone else? I don't want to make sure everyone got their chance, got at least one bite at the apple. All right. So I will say I have not myself had a chance to digest the letter from the Department of Labor. I was in transition because my internet was down at home, so I rushed here. So I'll be here for this meeting. But I'm feeling similar unrest that we probably need to look at that in more detail, look to see. I do hear that I'm hearing that the Delegate Rogers, is that your hand again?
Yes, Madam Chair, I was just going to finish your thought, but I don't want to finish your thought if you weren't ready to do it. And I was going to actually move.
You know me that well?
You know, just your taste in music, Madam Chair. But I was going to move this be a summer study, but I can wait till you finish your thought.
Yeah, and Madam Chair, if that's, I mean, look, if the sponsor's okay with the summer study, I think in a bipartisan way, I'd be okay with that general principle as well. So consider that a second if you'd like to see it go forward.
Okay, well, I will take that as a recommendation. And I think the sponsor seems to say that's okay. Delegate Watson.
I think it's important that we just define that, Delegate Rogers. Define sort of the summer study for anyone who might be listening that doesn't get the lingo.
Sure. So for all those who might not get the lingo, who might not understand what that means, and I would certainly defer to the sponsor to further delineate that as we do that study. But basically what we're saying is we're taking some time to look at this and examine what the data would do if we had some additional information, what those numbers would look like, either in a positive or negative manner. Did I capture that about right? Is that your understanding, Delegate Polakovich-Carr?
Yes.
So not that the subcommittee would be studying it during the interim, but that the sponsor would be doing a little more research and trying to work out any kinks that we've identified and then bring it back to us next session.
Sure.
And I would add to that, working with the Department of Labor and working with some of the other, stakeholders in this process.
Correct. Yeah.
Okay. Okay. Is that okay with you, Delegate Watson?
Yes, I just wanted to make sure we were defining it. That's all.
Sure, no problem. So, Council, do I need to have anything formal to say in terms of doing a summer study or
I would move to vote this to do that, just to make sure that, it's on the record. I would.
Okay. So, and I can do that? Okay. So I make a motion that we have HB 251 defined as a summer study where we outline the parameters and participants in that study to come back with recommendations on how we could address the issue that the bill is looking at, and that is protecting consumers as it relates to their credit reporting.
Second.
Yeah. I need a formal vote. Okay. Council, you want to read the names?
Sure. Delegate Adams.
Aye.
Delegate Fennell.
Aye.
Delegate Fletcher Harrison.
Aye.
Delegate Jackson.
Aye.
Delegate Mounts.
Aye.
Delegate Rogers.
Aye.
Delegate Watson. I will say aye, and explaining my vote, I just want to say to Delegate Carr that it's a really important issue. And I know I'm grateful that you're working on it, and we do need to try to provide relief for people in this situation. So thank you for bringing it to our attention, and hopefully we can work it out. Aye.
Okay. 1, 2, 3, 4, 5, 6.
Okay.
7-0.
All right. Well, thank you all for your time. I want to reiterate ditto what Delegate Watson say. Thanks, Delegate Polakovich-Carr, for bringing this to our attention as a subcommittee that deals with consumer protection. These are the types of issues that we need to deal with. So I look forward to something great next year. Hopefully I'll be back too, but listen,
Hopefully we'll all be back
to address this in the upcoming year. Thank you all for your time, and have a good afternoon. Bye-bye.
Thank you.
Happy Valentine's to everyone. Enjoy.
Happy
Valentine's Day.
Thank you. Happy Valentine's
Thank you
Day.
all.